Sir, serial number 41 MA87/17. LCR is available, my lord, but I have lost my record. Therefore, my lord, I am permission be granted to go through the High Court as well as the record of the case, so that I may assist, my lord. 41 MA87 जी इसे रिकॉर्ड देखने के लिए परमिशन दिया है.
Yes.
One thing, records are concerned, verified from the pleadings, the LCR is received. The driving license number is not mentioned in the written statement nor in the evidence of freedom.
Why not an adverse influence?
That may be, but one thing not here, but for the purpose of assistance to claimant there is no concern. Here one thing what I would gather from their written statement, para 19 is not a assertion as required in terms of ordering, because the principles of pleading will apply. It is a prayer. It appears to be a prayer made before the learned tribunal.
So they are not admitted also.
Insurance is admitted. Yes, they have not admitted.
They are not admitted.
They have, and one thing, it is absolutely correct, and as also observed by the Honorable, that it amounts to a fundamental breach of policy. But now the question arises for the purpose of adjudication is that insurance was there, which is admitted. Insurance is a contract. A contract was there between the insurer and the owner. There was a contract was there. If there is any breach of that contract, that will be subject to adjudication in another forum.
No.
So far as because the logic behind giving right to recovery, that has been taken into consideration in the surrounding cases.
So far as whether there was a breach of the policy, condition of the policy, that has to be decided in this motor accidents case only. There cannot be a separate case to decide it. There is a judgment of the Supreme Court.
Yes, but if there is anything in the policy that in absence of registration, these terms of this.
Now, can the policy go and say that your illegal acts will also be covered?
No, that is certainly
That
one
is
thing.
why the fundamental issue. That is the reason a gratuitous passenger, if he is taken in a commercial vehicle, your goods carriage vehicle, taking the same principle, the insurance company has to pay and then recover that.
Yes. But I tried to find out the case laws. The precedence is that what this Honorable Court observes, but it is in cases of cases decided by the consumer firms. Following the
maybe, but the principle has been decided. This is a fundamental breach.
Yes. And one consideration which
Let me do one.
and
So far as your driving license is concerned, also there is nothing on record.
Yes.
But before, what I think, let there be an additional evidence be recorded on an issue which I am framing, whether there is a violation of the policy or not, which will take into its sweep the driving license also and the registration also.
And one more thing.
You need evidence and let the court give a finding and send this to this court.
One more thing, Your Honor. So for the
then it will be the remand in terms of Order 41, Rule 23, capital A.
Rule 23 capital.
one of these, so far in this case, subject to consideration, but in this case, whatever the thing may be, the liabilities of the owner, we are satisfying the liability. We will be recovering from the owner, whatever it may be, subject to final result. So how this claimant is aggrieved? I am not aggrieved. I am found part of assistance.
Claimant is assisting.
Assistant.
Claimant is
But then in that case, can we see Rule 47 of Central Motor Vehicle Rules? When the application is to be made, what is the period? Because the insurance was made on 5/3/2013. Within 7 days of purchase of the vehicle, the application has to be made, which has not been done. So therefore,
it hardly matters if you say that it has not yet registered on the date of accident. It hardly matters. Whether he has applied for registration, even if it had applied on the very next day, would he be absolved?
no.
So it hardly matters. What you are taking it is of no consequence.
But one line
Considering the arguments case.
one line observation is there in this Narendra case decided by the Honorable Supreme Court, which has been followed even this last week. In that case, it was observed, like the facts in this case, as stated by the owner, that the registration was applied for, and on the date of accident, that application was there. It is not that application was not there. one in para 12 of this Narendra case. If also kindly have this, or I will just read out. Indisputably, a temporary registration was granted in respect of the vehicle in question, which had expired on 11/1/2006, and the alleged accident took place on 2/2006, when the vehicle was without any registration. Nothing has been brought and referred by the appellant to.
That is why I am demanding it. If there is any temporary registration, also they can
Yes.
bring to the notice.
Yes, and only one Placidum G, where the.
Don't read Placidums.
No, not Placidum. This small Placidum G, lots of para 12 only.
Para 12.
Para 12. Yes, para.
I thought head notes.
No, not at all. Para 12 and small G Placidum.
Where is it?
Have lots of got 2014 9. Last but one paragraph in SSC.
Yes.
Last but one paragraph, starting with the words when the period just after comma, 11/1/2000, the para starts with indisputably.
Indisputably. Yes.
In the middle words, where I was reading facts of this, in the middle after 11/1/2006, there is a comma.
Yes, yes.
When the period of time expired, the appellant owner will either applied, the appellant owner of the vehicle either applied for permanent registration as contemplated under section 39 of the Act, or made any application for extension of period. So this line I was stretching, that either applied for permanent registration as contemplated under section 39.
During the course of argument, the learned counsel for their appellant insurance company submitted that there is fundamental breach of the terms and conditions of the policy. He submits that the first breach was that the vehicle was being driven without a valid driving license. The offending motorcycle was driven without a valid driving license. He submits that in view of, he submits that in the written statement filed by the owner, he had not disclosed the number of the driving license. Thus, in view of the judgment delivered by the Honorable Supreme Court in the case of Pappu versus
Vinod Kumar
Lamba, adverse inference should have been drawn against the owner and right to recovery should have been granted by the jury. He further submits there was another fundamental breach of the policy, as the vehicle was driven without a registration number plate. He submits that driving a vehicle without displaying the registration number is a fundamental breach. According to him, in the instant case, the registration of the vehicle was registered after the date of accident. Next slide. The counsel appearing on behalf of the owner of the motorcycle submits that there was a valid driving license. Next slide. Considering the submission of the parties, I have gone to the impugned judgments. The impugned judgments, in the impugned judgment, I find that 7 issues were framed, 6 issues were framed. Though there was an issue in relation to the driving license, yet the tribunal did not frame any issue in respect of violation of conditions of terms and conditions of the policy.
And 5 has not been answered even.
Further, I find, where is the answer of 5?
There is no discussion.
There is no such specific.
Further, I find that there is no such specific discussion in finding about issue number 5 in 4,
sorry.
Roman 4. Issue number 4. Next one. CPC.
Remand will be under order.
A 3. 25 or 23?
Lordship, there are three situations. 23 is remand of case to appellate court.
Limited remand.
Remand is upon a preliminary point, and the decree is reversed in appeal. So here this
It will
will
be 25.
Yes, here this will not apply.
Limited
Appellate court
remand.
will issues and remand
25.
Limited remand.
25. Order 41 to 25.
25.
Does this court feels that this court does this court is exercising jurisdiction under order 41 to 25 of the CPC? First one. The following issue is framed.
Recast.
Is recasted. It's not framed also. It's following additional issue is being framed. Whether there is any violation of the terms and condition of the insurance policy. Number two, in the insurance policy, number two, whether the vehicle was registered, whether the motorcycle bearing number so and so were registered at the time of accident.
ऑन इसको मैं स्क्रीन पे नंबर दीजिए, दिक्कत हो जाएगी. वो रजिस्टर और
Whether the motorcycle
offending
motorcycle bearing engine number and chassis number was registered on the date of the accident.
that would be more clear.
Number three, whether the driver, the rider of the motorcycle possessed a valid driving license to drive a two-wheeler, and if yes, the two-wheeler first. These aforesaid three issues are absolutely necessary to reach at a correct conclusion. Just and correct conclusion, proper conclusion. Thus, I direct the motor vehicle accidents claim tribunal number so and so in MA type this case in MA number 276 of 16 to take additional evidence for
record
additional evidence and try the same issue and return the file with the observation findings and return the file with the findings before this court. The tribunal should complete this exercise within 3 months.
कभी भी करो.
3 months from receipt of the records along with this order.
अरे रिकॉर्ड की कोई जरूरत नहीं, जेरोक्स कॉपी यहाँ पर है. जेरोक्स कॉपी है यहाँ पे.
What are the records?
Xerox copy.
Within 3 months, so that this court can proceed thereof based on the findings. You have not paid any amount.
लग नहीं रहा है.
And entering 50,000 per
If एक चीज कर दीजिए, if not paid हमको इंस्ट्रक्शन.
इसको इसमें टाइप कीजिए, इसमें टाइप कीजिए, 37 में टाइप कीजिए. What is the age of the deceased?
36 years.
What is the monthly income?
6,000.
Oh, that's the 6,000.
Yes, that
वो नहीं वो नहीं, उस पे हमने कोई मल्टीप्लाई
6,000 into 12 into 13.
डिडक्शन इज 1/3.
9,36,000.
Initial 1/4, deduction is 1/4 instead of 1/3.
1/4 होगा कि 1/3 होगा?
1/3.
1/4. चार
Four
dependents. Four dependents.
1/4 होगा.
1/4.
10,52,800 principal amount.
प्रिंसिपल ये पेड कर चुके हैं, इंटरेस्ट का बाद में पे करने का
Considering the nature of the appeal, which is for enhancement of the compensation amount, I direct the insurance company to pay a sum of rupees, this was 50 billion,
50.
10 lakhs to the claimants by way of intervention.
भाई सब्जेक्ट
Please final disposal of this.
एक बात बोली सब्जेक्ट टू वन ऑब्जर्वेशन में भी गिवन, जैसे कि क्लेम ट्राइब्यूनल हर एक केसेस में जो कर गए हैं आजकल कि इट विल बी डिसाइडेड इन अदर कोर्ट एंड ये करके जो है वो but when take those copies of
No, I am not passing any final.
but when we take your copies of those
Both the orders, copy of both this order should be faxed to the court concerned and should also be handed over to Mr. Upla and Mr. Atul Rai.
and what is that copies
And Mr. Upala.
It is allowing future prospect of 40% at the rate.
40% future.
But
And it will come to 10,52,000.
I have a calculation subject to it is tough. Because I have reduced the multiplier to 15 and also
What will be the multiplier?
multiplier should be 15. 16 has been allowed. I have made it 15. I have just marked it.
15 ही होगा मल्टीप्लाई
I have calculated on 30.
मैं ठीक हूँ बाद में जो जो डिफरेंस है कोई दिक्कत नहीं
अभी भी कुछ मिलना चाहिए.
पर मैं रिटर्न those copies
And the interest amount also it will be okay.
and that will be that is why lump sum amount is to be paid to you but when you take those copies decide photo copies
Yes, yes, we take it. I agree with you.
Obliged.
Just a minute.
yes
What is the amount? 6,000
6,000.
into 12 into 15.
Yes.
Then into 3 divided by 4. So 8,10,000. 8,10,000 into 140%. 11,34,000.
Yes.
Plus 70, how much? 11,34 plus 70? 12.
12 lakh 4,000.
12,04,000.
Yes, exactly. That is
12
my,
lakh कर दीजिए, pay 12 lakhs.
that is my calculation.
So interest will stop from today.
हाँ ठीक है कर
12 lakhs. Return नहीं करके 12 lakhs. नहीं 12 lakhs 50,000 less होगा.
12 lakh 4,000 minus 50,000.
let it be 11 lakh let it be 11 lakhs
11 lakh 54,000.
11 lakh 50,000. Pay a sum of rupees 11 lakh 50,000. So the interest liability will stop from today.
Yes.
Over 11 lakh 50,000 the interest will be done.
so for at least the one thing that right of recovery may remain intact
That I will decide. Right of recovery will come only.
there will be
What
after
evidence?
these findings
What evidence is there?
after these findings
After this is decided on demand.
मतलब पेमेंट करने की थोड़ा इसी टाइम पे दिया जाए
It is expected that the payments should be made within a period of 10 weeks.
हाँ because there is a fire in the office of National Insurance Company so entire records and the computer just got burned
Obliged.
10 weeks. Yes, next.
Serial number 38, MA number 324/70, Mr. Vivas Sinha for appellant.
28. Sorry, Mr. Vivas.
Please time of I am opinion.
Yes.
So we have agreed with the part of the order by which the ad interim with compensation of rupees 50,000 was awarded under 140 of the Act. So kindly see the nature of the allegation first. Then I'll question.
Allegation.
No, the nature of fact of the case. Page 12.
Page 12.
Yes, ma'am.
Yes.
घटना के संबंध में प्राथमिक भी दर्ज कराई गई है जिसमें सूचक हारून अंसारी ने अपने फर्क बयान में कहा है कि दिनांक 14/6/2014 को समय करीब 6:30 बजे शाम में अपना बयान दे रहा हूं कि मुदीन अंसारी बेल का व्यापारी था उसी के साथ गोपाल ठाकुर और सूचक लेबर का काम करते थे सूचक मुदीन अंसारी के घर पर 14 बेल हटिया ले गए मुदीन अंसारी बाद में आया और 10 बेल बेच दिया 4 बेल भगीना अंसारी को रखने के लिए दे दिया और मुदीन अंसारी से ससुराल से चूल्हा लाने के बाद मुदीन अंसारी, गोपाल ठाकुर एवं सूचक मोटरसाइकिल पर बैठकर अपने गांव बांका हटिया जा रहे थे कि करीब समय 3:45 जब ग्राम बांसजोरी के पास हटिया रोड के सामने पहुंचे तो पीछे 2 काला रंग का मोटरसाइकिल आया और हम लोगों को मोटरसाइकिल को घेर लिया। पांचों आदमी मोटरसाइकिल से उतरकर मुदीन को पकड़ लिया और 2 बदमाश पिस्तौल निकालकर भिड़ा दिया। यह देखकर हम लोग काफी डर गए और भाग गए। उसी समय
issue notice to the opposite party member.
Notice has already been served on white order. It was reflected notice 29/3/2022.
Will the subject will be heard? Admit all will go on records. In the meantime, considering the nature of the fact of this case, the order dated 28 February 2017, passed by Motor Accidents Team Tribunal, Gurkha, in MACC case number 76 of 14 will not be given.
Okay.
Issue notice after the issue notice, or the process to other respondents.
Okay.
Under the heading for hearing, serial number 40, MA number 66 of 10, Mr. Alok Lal for appellant, Mr. Sudhir Sai for respondent.
But in this case, this is also the similar nature of case which by Leonard Pranadaru just before that. In this case, it is the bus was involved. There was some roadblock, and the bus was not allowed to enter ahead. So therefore, all the passengers they started getting down from the bus, and he was assaulted and died. So in this case, recently or yesterday only, I have checked up from the e-court site that the main claim application under 166 has been decided on 29/7/16. So I am not aware of this because the order is not uploaded. So they let in this case it's under 140.
So it will not change that final order.
So but I am not aware of that order. So therefore, it was not.
So if it is allowed, you have to challenge. If it is dismissed, you have to challenge.
But let me accept. Let me.
No, 140. Why should I keep it pending? Because in view of Mr. Alokla fairly
But let me check it up because
Website is showing that case has been disposed of.
you are the
I'm owner of the vehicle.
The owner of the vehicle, operating vehicle, that is respondent number 1, submits that the compensation case number 53 of 2008, filed under section 166 of the MV Act,
has been decided on
has been decided finally
29/7/16.
on 29/7/2016.
So dating है ना?
Has been finally decided. Good, sir. It is submitted from the impugned order. I find that the same was passed under section 140 of the Motor Vehicle Act. Good, sir. Next one. Since the main application has already been, since the application under section 166 has already been decided, I am not inclined to pass any order to this appeal. The parties will be at liberty to raise all the points if at all any appeal is filed against the judgment under section 166.
Yes, this was a statutory amount maybe.
The statutory amount is likely to be refunded to the insurance company. This appeal is disposed of as infructuous.
Well, I try to even I try my best to find out this detail.
Any one of you can find the appeal.
Any one of them. That liberty is there. Payment is there. Just not payment has not been.
Serial number 41, MA number 87 of 11, Mr. DC Ghosh for appellant, Mr. Rohit, Mr.
But
Rajan.
one more thing, my lord, in this case, by Leonard has pointed me out that amount was directed to be deposited, your lordship. In this case itself, which has been disposed of by your lordship, the 140.
It will be the final, which amount has been taken?
50,000 has been deposited in that case
Where?
before the court below, because in terms of order dated 3/9/13.
So it will be subject to the final, this deposit is also just subject to the 166 application. You see what has happened? Yes. Yes, what is this?
Appeal. Let the, I've just gone through the record of the case, my lord. The
Case of death,
death case.
age of the deceased,
Let just I'm coming. My lord, the liability is under challenge, my lord.
what is, why,
On the truck, deceased.
passenger,
But the claim of the claimants is that deceased was
owner of the goods,
after buying rice, owner of the after buying rice was going to Kandra. Now,
which,
well, regarding the defense of gratuitous passenger taken in para 4 of the written statement, from the FIR it is appearing that the truck was loaded with bauxite, and from the evidence of claimant witness number 1, running page 36 of the LCR, witness of Dev Mohan, para 3, it is appearing that the truck was loaded with bauxite
what is the
and
quantity of
Arahatha.
what is the quantity of the rice was carried?
From the entire record, I have not found
5
any.
sacks of rice,
Somewhere 6 sets also.
5 to 6 sacks.
And he had
जो हम मिस कर गए देखने में, मेरा पूरा रिकॉर्ड मेरे पास नहीं है, हम अभी जस्ट, और क्लेमेंट विटनेस नंबर 1 का स्टेटमेंट है पैरा 3 में, बॉक्साइट लोडेड ट्रक आ रहा था, फिर जीरा में है, जीरा का पैरा 2 रनिंग पेज 38 ऑफ द LCR, सेम एनवायरमेंट, और एंड owner of the vehicle filed written statement denying the fact of this rice, denied the carrying of fact of rice. Therefore, it is only for right of recovery. Now, from the FIR, claimant witness number 1, it is apparently clear that the truck was loaded with bauxite and thereupon the deceased was. Yes. डिटेल में तो हम जा नहीं पाए हजूर, सबमिशन में कुछ इधर उधर हो सकता है। और नहीं तो एक डेट दे दिया जाए, हम नेक्स्ट डेट में देख लेंगे।
Paid the amount.
मालूम यहाँ पता है, पुराना केस है, इसमें पेमेंट नहीं होता था हजूर उस समय,
Payment नहीं हुआ,
उस समय होता नहीं था,
2007 का केस.
उस समय पेमेंट होता नहीं था।
You see the amount which has been paid. Supreme Court now says a 7-year-old boy is entitled to receive
सर्टेनली
4 lakhs or 5 lakhs. 1 lakh, 32,000 only. And he's the owner of the goods. Does it mean that a person, if he is transporting something, he has to take on hire the entire vehicle? Suppose the truck,
जी
suppose a truck's capacity is 12 ton, and 5 ton bauxite has to be transported and 3 tons of waste. Can't it be transported in one vehicle? Where is the law that a person wants to transport his good, he has to hire the full vehicle? Even
Just
if
now I have
the
not-
capacity of the vehicle is much more
Just
than
now I have not that decision, but there is one full bench decision in case the owner of the goods hires a vehicle. In that case, he has to enter into an agreement with the owner of the vehicle.
What type of agreement? Written agreement.
Written in one full bench is
In
there.
contract act, oral agreement is also valid. As per contract act, oral agreement is also valid.
No, not oral,
And
written.
this agreement is not a compulsorily registrable agreement, which needs registration.
That.
Then
To
why
show
not?
to show and establish the fact that yes, the owner of the goods has hired the vehicle. Similarly, more similar from the
Tell me one thing, Mr. Ghosh.
anyhow, my lord.
In a goods carrying vehicle, the driver of the vehicle can't be said to be the agent of the owner when he is taking some goods on hire. So we deem that he is the agent of the owner and he knows owner, he was authorized by the owner to be. Just on a broader sense.
Yes, of course, in many cases here, my lord,
1,32,000. Your insurance company will spend more than this by paying lawyers fee.
लॉयर्स की 1 लाख कभी नहीं होता है, लॉयर्स की 1 लाख कभी नहीं होता है।
Mr. Counsel, just give me
नहीं,
your
नहीं,
lawyers fee.
नहीं, lawyers नहीं होता।
What?
अब वहाँ पे है
Then
50,000 they pay lawyers fee,
in High Court.
50 Supreme Court.
So you could be like, no will argue your case for.
No, retailers are they are being paid, जो हम लोग करते हैं 50,000 ही पे करते हैं, that is the fixed fees, Supreme Court.
So you got no lawyer in charge. Even a lawyer who has joined 2 years back, you will also not charge.
Because we have the schedule, they pay 50,000.
so right of recovery, अभी तो just whatever.
Evidence.
Evidence, running page 36. Evidence of Dev Mohan.
This appeal, the appellant insurance company has challenged the award passed by the Motor Accidents Claims Tribunal, come District Judge, Florida, in compensation case number 22 of 2005, whereby an amount of rupees 1,32,000, no, 1 lakh means 1,82,000 has been assessed as compensation and directly paid to the claimants. Next. It is the case of the applicants, claimants, that on 7/5/2005, the deceased Handu Ora was bringing rice to Kandra from Serenga. He was traveling in the offending truck bearing registration number. What is the registration number? BR 14A capital A 230 as the owner of the goods, that is 5 or 6 sacks of rice. It is the further case that the driver was driving the vehicle in a rash negligent manner, as a result of which he fell down and crushed under the wheels. The claimants claim compensation. The insurance company appeared and filed their written statements And their main plea was that the deceased was a gratuitous passenger in a commercial vehicle, and thus the owner is liable to pay the compensation amount from the insurance company. On the basis of the pleadings, the tribunal.
May I interrupt?
Yes.
In this case, it is that he boarded the truck, he unloaded 5 sacks of rice. 6 sack he unloaded, and after being unloaded, before he came to the site, it was crushed by the gearbox.
Before the four issues were the 7 and 8 issues were framed by the tribunal. Also, issue number
Issue number 5 is the issue of gratuitous
issue number
passenger.
5 and 6 needs to be reproduced, which are as follows. 9 documents were also exhibited, which included a FIR charge sheet. Copy of the owner book, Xerox copy of the owner book, policy paper, permit, goods carriage permit, tax token, postmortem report, certificate of fitness. The tribunal also recorded a statement of the oral witnesses on behalf of the plaintiffs. CW number 1 is the eyewitness of the accident. He deposed that in the morning, he was having breakfast in a hotel, in a roadside hotel, when the loaded truck, a truck loaded with bauxite, bearing number 14A2301, came and stopped there. The deceased got down from the truck and was unloading 5 sacks of rice. But before he could get aside, the truck suddenly moved and crushed him. Crushed him, resulting in his death. CW2, which
CW is the
White.
wife.
CW2 is the wife of the deceased.
नहीं वाइफ नहीं है, कोई सिंग करके है।
CW2 is the itself.
Uday Singh.
Mr. Ghosh,
जी सिंग करके है।
what is the
पेज
year?
पेज 38
Page
पेज 38
38. 41 से शुरू.
रनिंग पेज 38 ऑफ दी मैंने गवाही का
Okay, this one. Running page?
रनिंग पेज 38
2 is
Uday Singh.
Uday Singh. Who is not eyewitness, but a resident of the same village, who was a co-villager of the deceased. He received information about the death of the deceased. He stated that after unloading the rice, he alighted from the truck when the truck started and crushed him. Vehicle number 3 is Umesh Tiwari. He is also eyewitness to the occurrence. He narrated the same event. He narrated the same story which has been narrated by the eyewitness. The tribunal, next one, the tribunal considering the evidence of the record, assessed the compensation to the tune of 1,82,000. Along with interest at the rate of 6% per annum from 34,007. Next one. The counsel appearing on behalf of the insurance company submitted that admittedly the deceased was a gratuitous passenger in the goods carrying vehicle. Thus, and since no additional premium has been paid by the owner, the insurance company is not liable to pay any compensation. He submits that evidence clearly suggests that without any authority, the deceased was traveling in a goods carrying vehicle. As per him, the witnesses have stated that the vehicle was loaded with bauxite. That be so, it cannot be said that the vehicle was taken on hire by this applicant, but by the deceased for transporting his 5 to 6 sacks of rice. Next one. Counsel appearing on behalf of the claimants submits that there is a consistent evidence.
I'm not the owner.
Owner submits that there is a consistent evidence that after the day that the deceased was traveling with his goods, that is 5 sacks of rice.
My lord, subject to my lords, before the court below, owner himself in para 7 of the written statement has denied.
No. The owner in the written statement has denied the opposite fact that the deceased was
Carrying.
goods
Nice.
and has hired the vehicle. Mr. Bush, tell me this facts which is coming in witness. He was carrying with the goods, even if he is a gratuitous passenger. Once he has deboarded,
That is the
can he say to be a passenger?
that
He has deboarded. He stood there. Then the vehicle started and crushed him.
but from the evidence, it is appearing that the relation of the deceased with the vehicle
Will come to an end when?
has not come to an end.
It will come to an end when, I am asking you. I want to know this.
He is just putting down his
He has
goods
put down
from the
his-
vehicle.
He has
Of course, from the judgment, perhaps I have seen one Andhra Pradesh decision has been cited in while dealing with issue 5 in favor of the claimant owner of the. That decision is there.
he has unloaded all his goods.
Whether that is now the question will arise, my lord, whether the total unloading of the goods was complete or not. That
Since the evidence says that goods were unloaded. Or
my lord,
Though the owner in the written statement has denied the present that this was
after hearing the parties and after going to the report, I find that the only dispute which is involved in this appeal is whether the appellant can be said to be a gratuitous, whether the deceased can be said to be a gratuitous passenger. From the evidence of CW 1, 2 and 3, I find that it is a consistent case of the claimant witnesses that the deceased was traveling with 5 to 6 sacks of rice. He was carrying the goods. It is the case of the claimant that he was traveling in the sage truck along with his goods. Thus, he cannot be said to be a gratuitous passenger. The owner stated that in his written statement had taken a plea that the vehicle was not taken on hire by the deceased, and he had got no knowledge about the same. Admittedly, the vehicle is a commercial vehicle which runs in hire. The driver and the deceased would not have boarded the vehicle along with his goods without the consent of the driver. The deceased was carrying 5 to 6 sacks of rice is also not disputed. So thus, it can be said that the driver had knowledge and had consent. And with the consent of the driver, the deceased loaded the goods and the vehicle. Thus, in this case, it can be said that the driver acted as the agent of the owner. So far as hiring of the vehicle is by the deceased is concerned, I find that it was the duty of the owner to controvert the statement made in the claim application or made by the claimant's witnesses, which the owner has paid. Thus, the statement which has been recorded, thus the deposition of the claimant's witnesses cannot be questioned on the fact that the deceased was traveling as the owner of the goods along with his 5 to 6 sacks of rice. Be noted, there is nothing in law that if a person wants to hire a vehicle for a small quantity of good, he has to hire the entire vehicle. He can hire a part of the vehicle which would be sufficient for him to carry his material. So there is nothing against the deceased in the award nor in the evidence. Thus, I find that the tribunal has correctly concluded that the deceased was not a gratuitous passenger and was carrying his goods. And as the owner of the goods, he was traveling.
No, my lord, the finding here है issue while dealing with issue 5, he is not a gratuitous passenger as because he has already been terminated.
He is the owner of the.
No, he had
Already utar gaya hai.
Further,
Yes.
further, I find that the tribunal has found as here that since he has already deported along with the goods, this cannot be said to be a gratuitous passenger. This issue need not be gone into, as because I have felt that he was the owner of the goods and was struggling as the owner of the goods. Because one of the witnesses said that when he was alighting
from the cabin.
So this issue is a trickiest issue.
That to us.
Thus, I find no merit in this appeal. This appeal is dismissed. Yes?
Hello.
So now,
नहीं बोल रहे कि ट्रैक्टर को से अगर चढ़ के गिर रहा है तो फिर तो गिर गया नीचे उतर गया तो कैटेगरी से कैसे नहीं ऐसे ही जस्ट इसको लाइटर साइड में हम बोल रहे हैं ये पर्सन इज फॉलिंग डाउन फ्रॉम
जो कभी लाइटर मूड में रहते नहीं
लाइटर नहीं बोल बोलेंगे
सुबह से शाम तक।
अगर वो फाइट गिर रहा है तो भी तो नहीं ना रहा होगा हवा में रहा तो गिर गया तो यही हम बोल रहे हैं
Alright.
Next.
Serial number 42, MA number 120 of 12, Mr. Arvind Kumar, Mr. Chandrajit Mukherjee.
Thank you, Lordship. Lordship, I have tried a fresh of alpha for the claimant respondents in this case. Lordship, I have not received him by LCR today. I need to examine it, Lordship. I was only waiting for
You are the,
claimant respondent, Lordship.
what is your ground?
Your Lordship, my ground is that I am not the insurer of the offending vehicle, because the deceased, he was going on a motorcycle, and offending vehicle hit the motorcycle from backside. So it has come. The charge sheet is against the unknown driver. FIR is against the unknown driver in the vehicle, and I am nowhere the offending vehicle.
Who are you?
I am the insurer of the motorcycle on which the deceased was traveling.
What is your good name?
Soumya Pandey.
Ms. Soumya Pandey submits that she has filed Vokalatam of yesterday,
No, recently, Lordship.
recently, and has not gone through the lower court records. So she wants to inspect the lower court records, for which she pays what? 3 weeks? 2 weeks is enough. 2 weeks time. This is up 2 weeks.
Serial number 43, MA number 214 of 50.
This matter was heard on the last occasion by Your Lordship, that is Act liability policy and the package policy. So certain judgments I have shown under the policy is the Act policy, that he was the person who was travelling in the private vehicle. So therefore the insurance company cannot be held liable. That was and some of the judgments I have also relied upon. Of this honorable court, I have, yes, it was a part of it.
Yes.
My learned friend was asked to argue a reply on those issues.
What are the judgments you decide upon?
Well, I relied upon the judgment, that is, one was of our own High Court, that is Branch Manager Oriental Insurance Company Limited. Citation. That citation was 2009 Volume 1 JCR 556 Jharkhand. And
Next one.
the next one was
2006 Volume 5.
2009 Volume 1 JCR
JCR.
page 556 Jharkhand.
6 Jharkhand.
And the other was 2011 Volume 1 SCC, SCC 2009 Volume 1 SCC 301, that is General Manager United India Insurance
2009
Volume 17 SCC 301, General Manager United India was M. Lakshmi, and the other one was, that is, perhaps it was not with regard to the SCC is not there, so I refer to the Supreme Court perhaps, or JCR. JCR would be better, no? 2012 Volume 11. No, that is, number is something wrong. Yes, 2013 AIR Supreme Court 473. The name is National Insurance Company.
AIR Supreme Court. Page.
That is
2013 AIR SC page.
SC page 473. There is something error in the page.
You give the correct numbers.
The number, I'll give the.
Give the correct citation. Page number
2013 Volume 1 SCC 13
2000?
Volume 1 SCC 731. 2013 Volume 1 SCC page 731. National Insurance Company Limited versus Balakrishna. And the other was 2013 Supreme Court 483 Oriental Insurance Company Limited versus
Volume?
Supreme Court. AI Supreme Court.
Yeah.
AI Supreme Court.
Yeah.
Supreme Court 13 Supreme Court 483 and Lakshmi is there, Balakrishna is there. And Vidura.
So it was a third party insurance.
It was a third party insurance. And one of your lordship, their lordship in this, and there are, and the first one would be, one of in this case, the leading judgment in this case would be 2006 ACJ 1441. 2006 ACJ 1441 Supreme Court, United India Insurance Company Shimla versus Tilak Singh. So this was the first case which was decided, and in Surendranath Lumba and Balakrishnan case, the ratio has been let out. Why in these cases, in the Act policy, the occupants are not covered, only in the package policy, the occupants are covered statutorily. Because of there is some wordings difference in the Act policy, and this, those has been discussed in all these cases, Your Lordship.
See, the facts are admitted. This Jeep, you were the occupant of this Jeep.
He is the owner. He is the owner.
Sorry. Who is the claimant? Yes. The claimant, the deceased, was the occupant of the Jeep who went to attend a marriage party. While returning, the vehicle turned curtain and he died. Most probably the informant is the father-in-law of the deceased. Now, the policy is Act policy or a comprehensive policy?
Exhibit 4.
Or what is the word used?
मतलब there is only only liability only policy होगा, वही होगा या Act policy होगा?
Or the Act policy.
Or the Act policy. Liability only policy or the Act policy.
And if it is comprehensive, it is written as
Package policy.
Package policy.
It is package policy. जा चुका है
Private car policy.
बस
What is private car?
प्राइवेट कार पॉलिसी से एक्ट लायबिलिटी उसमें केवल देखिएगा कि उसके कॉलम जो है ओनली दी थर्ड पार्टी दिया है, वो ओल्ड डैमेज का नहीं दिया हुआ है,
Liability only.
लायबिलिटी ओनली,
What do you mean by liability only?
liability only to just to cover the liability under the Motor Vehicle Act 147, nothing beyond that.
Why are you saying this? What is?
But those issues have been discussed in the old Balakrishna and Surendra Lumbala cases. 147 I am reading again. See, the occupants have not been considered to be third party. They are taken to be the part and parcel of the owner. They are not the third party. Any person who is not connected with the owner will be a third party. Now, 147 may kindly be seen for a moment.
Yes.
Requirement of policy and limits of liability. In order to comply with the requirements of this chapter, a policy of insurance must be a policy issued by a person who is authorized insurer, insures a person or class of persons specified in the policy extent specified in subsection 2 against any liability which may be incurred by him in respect death or bodily injury to any person, including owner of the goods or authorized representative carrying the vehicle, or damage or any property of third party caused or arising out by use of vehicle. So this is not, this totally excludes the occupant. This totally excludes the occupant. Now let us come to the next one. Any against death or bodily injury, any passenger in a public service vehicle caused by or arising out of the use of vehicle. So it is not a public service vehicle. So therefore this also excludes the occupant in a private car. So these terms of policy specifically excludes the person who are occupying the seat in the private car. Now, for certain persons, they are no extra premium is required to be paid.
It excludes the driver also.
Kindly come forward. ड्राइवर के लिए एक्स्ट्रा प्रीमियम की जरूरत नहीं, है स्टैट्यूटरी कवर. देखिए इसमें देखो नीचे आ जाइए ना. Provided a policy shall not be required to cover liability in respect death of arising out of in course of employment. B उसको प्रोवाइडो में आ जाइए. Come to proviso 1. Come to A. 1A. Engaged in driving of vehicle. So the driver is already covered. So therefore no specific payment is to be made for the claiming compensation.
Where have you said it? Where it is?
Well, provided that the policy shall not be required. Proviso to 1. Just engaged in driving of the vehicle. I'll read that whole one. To cover the liability in respect death or death arising out of the in course of employment is the requirement of the employee or a person insured by the policy in respect of the bodily injury sustained by
which clause?
147.
Yes.
147. There are subsection 1A. A is having A and B.
By a person who is authorized with the insurer. 147A is issued by a person who is an authorized insurer.
हाँ उसके बाद B है.
He is insures the person or class of person specified.
Yes, that can be that we have now B2 see B2. And thereafter the proviso is there.
The death or bodily injury.
Yes, after that see the proviso provided that explanation the provided that the policy shall not be required to
for removal of doubts, it is hereby clarified that the death or bodily injury to any person or damage to any property of a third party shall be due to the cost.
No, don't leave it. Please leave the explanation. Just before the explanation, there are certain clauses. Just before the explanation, there are certain clauses.
New acts.
The new act will not apply, Your Worship. This new act will not apply. We are governed by the 88 Act. I am giving the book, madam. I am passing on my book. Kindly take this one.
Why don't we exhibit the entire documents? We exhibit only the first page.
Well, in fact, this was brought by the claimant and the owner. So we are admitting it. You just see that after the B proviso that engaged in driving of the vehicle. So driver is not statutorily required to be covered under the Motor Vehicle Act. A person may pay premium for his coverage under the WC Act to have a wider liability, wider legal liability.
Yes, what are the judgments? Have you gone through the judgments, Mr. Counsel? This Balakrishna.
Balakrishna and Surenath Lumba and M. Lakshmi. They are very clear on those issues.
Well, this is the case where the director of the vehicle was traveling the company vehicle.
Yes, it's company vehicle. So,
It is held as the act only policy.
act only policy.
So in an act only policy,
Meena Varyal is also there.
what happens if the owner is the driver?
Owner is the driver. That owner will be the first party or the second party. So owner cannot claim compensation against.
No, but as per 147 says the owner did not take.
The
driver did not take.
Driver did not take. But here in that case.
But if he is a driver.
He is a driver. So in that case.
What happens if the owner is the driver?
No, in that case nowadays, in the old policies, there was no such clause. Nowadays, in the policy, there is a mandatory, the coverage, PA to owner come driver is being taken. Mandatory.
It is a personal accident.
No, but it has become mandatory under the old act during those times because of these.
That is a personal accident coverage.
Personal accident coverage.
That is limited to, say, suppose, a limited sum of money.
No, that is limited sum of money. That is only limited.
Yes.
But in this case, he is either the contracting party, so one cannot claim.
Just.
Now I am going to tell. I will explain one. The thing is that whom we are insuring, indemnifying the owner. Now he is the contracting party between there are two parties. First party is the insurance company or the owner, or vice versa, whatever it may be. Whether one can claim, we are just an indemnifier. In a wider perspective, if we examine whether one can claim compensation from himself, from the indemnifier, from the insurance company. We are an indemnifier. So unless and until special coverage is obtained by the owner in the policy, we cannot indemnify him. We will not indemnify him. So that is why nowadays it has become a mandatory in all these policies, whether it is a package policy or the act policy, that coverage is being given. So therefore, in all such cases, my lord, in which case the owner, the person is buying your vehicle. Suppose if I take your lordship's vehicle for a moment, and if there is a accident, then in that case, I will be stepping into shoes of your lordship's car, the owner, the insured. So whatever the compensation is to be paid, that will be paid to me. That is the Ram Khilari judgment, that is the recent judgment of the Honorable Supreme Court, that borrower of the vehicle cannot claim compensation more than what is the owner can claim.
Yes, what do you have to say? This judgment says 2013 says the occupier is not entitled to claim.
Yes, and we have paid 4 lakhs. In this case, we were executing court, out of which 2 lakhs were permitted to be withdrawn. And of course, 50,000 has already been paid.
In this case, the matter was limited because it was not possible to decipher whether it was a comprehensive policy or a package.
Yes, but here in this case,
it's liability only.
Liability only policy. That is there. That way the case was remanded in Balakrishna. And in Kunti Devi is very clear in those issues. Case of Kunti Devi, our own High Court.
Yes, Mr. Nair, what do you say?
Have you gone through it? Have you examined this legal proposition? Which has been laid down.
The last occasion has taken time for.
Issue number 4. Is there any violation of the terms and conditions of policy by insured? If yes, who is the circumstances is liable for payment of amount of compensation?
No, there is not a question. This is not a question of violation of terms and conditions. Violation will come when there was a policy covering this person and there was some violation.
Driving license was not there or permit was not.
He was not covered by the policy.
Covered by the policy.
Says that the disease was not covered.
Perhaps Kunti Devi has answered these questions, Your Lordship. Our own High Court.
Where is it?
That 2009 volume 1 JCR. Kunti Devi has covered all these things. But I'm having from Manu Patra. Paragraph 9, penultimate paragraph.
Passenger carrying weight, what I personally feel.
No, that is a premium. Person carrying, that is a premium. The premium
It
is.
should be made compulsory. In a passenger carrying vehicle, the number of passengers, its seating capacity is fixed.
Seating
To the
capacity.
extent of seating capacity, it should be made compulsory.
It should have been, but now what is happening practically what is happening, I will not disclose. Whenever the person goes to the insurance company, outside the court, I will tell a story, which is a very true story here, within our High Court itself, that one wants to pay the minimum premium. Now the policybazaar.com, these persons, they are offering, that is why they are offering the premium at a lesser rate. There are not something which is not covered. For each and everything, suppose if...
And I think that when you advertise, when each company, insurance company on these websites, they advertise that they will facilitate the insurance, they should advertise in their website against a particular policy or in the premium, what is not covered rather than what is.
It is everything in the policy, everything is covered, open. But the thing is that
what is not covered, that should be highlighted. These are not covered.
But because in these cases, this GIC Council, they should make the guidelines. GIC Council, they should make the guidelines, because and there is no policy, none of the insurance companies which I have seen. Because number of times, because I have talked to the.
Now you see when you go to purchase insurance policy of a vehicle, they'll say zero depreciation policy, engine coverage policy, X, Y, Z, loss of key policy, return to invoice policy. These are 5 or 6 types of.
These are five add-on coverage. But the people,
but they should say what is not covered.
But the people.
Passengers not covered.
No, that is what I am submitting, Your Lordship. I have so far I have said all my friends, those who are having the vehicles, asking me for, you tell me, ask someone to come and collect the premium. So I tell the agent also to take the premium for the occupant also, even if they say that premium is going to high, take that premium also. But the people, they say that no, jitne kam mein ho sake utna karo, because they say that it is the waste of money. Now the same thing, suppose if a train is going from Ranchi to Howrah, there are several type of coaches are there, and one is buying a ticket for AC sleeper class and say, because the train is the same, reaching point is the same, time is the same, so why should I not be given the facility for AC first class? Because that is why the policybazar.com and these policies which are being advertised, these are the hidden things which they do not, they never disclose. And the people want to get a minimum premium. Normally after the 3 years or 5 years of the vehicle, the people choose not to get the maximum coverage, which one can get. Even my that's Maruti 800 is 32 years old, they say, sir, aap yahi liye, no, I'll take that premium for the occupant also. And third party property damage unlimited.
So your 32-year-old Maruti has to be scrapped.
No, why should I? Because no, where is the policy? I'll pay the green tax.
No. For how many years you have to? Till how many years it has to be registered?
After 5 years, I get it. I get it tested. I get it very.
15 plus 5 plus 5.
No, I get it checked. I get this certificate authentically.
No, most probably there's a.
There will be. But in that case, the green tax has to be paid. I pay the green tax. Considering the maneuverability of this Maruti 800.
Now, most probably after 20 years, as per the new act, it cannot be.
After 25 years, but the green tax has to be paid. That matters.
Then it is from the first renewal itself. Most probably. Just check it.
Then for first renewal, it is still there is time. First renewal was 2000.
Now the scrap. 7 except vintage cars.
So that will become vintage in 5 years. That is the first model of the Maruti 800.
It will not be vintage.
First model of Maruti 800.
Yes. Mr. Iqbal, what do you have to say? The only issue is issue number 1, which is admitted that this is a liability only policy. Act only. Whether this passenger can be said to be covered when no extra premium has been. And liabilities are upon you then.
This issue number 4 has been decided by the court below. That was staff in was 6.
Yes.
The judgment value. Which maybe
Page number 6.
6.
It is issue number 4. 6 is something that you to what relief are capital elements are issue number 4. 4.
Violation of the provision of policy by this court.
Yes. The vehicle was not hired. The vehicle was not hired. Admitted.
It has not been legalized.
Yes. The issue should have been whether this passengers are covered under the policy or not.
And 5 is there.
Have you paid extra premium for the passenger? Then, what is the nature of this policy? What is the type of this policy?
It is written at the corner. You see, you have encircled it. You see that one.
पॉलिसी में होगी पॉलिसी कवर यूज ऑफ द व्हीकल फॉर एनी पर्पस अदर देन
ऊपर आप जहाँ मार्क किए गोल उसको पढ़िए ना, वहाँ पे जहाँ पे मार्क किया ऊपर पोल काला वाला वो पढ़िए।
प्राइवेट कार पॉलिसी लायबिलिटी और
दैट इज द क्रक्स।
time is granted for searching out the policies, huh? Time may be allowed.
Thank God, it's a part and parcel, it's without, what time? Tomorrow? Tomorrow? For the tomorrow? For the tomorrow?
Can I have my book, Your Worship? Book, my book.
Where is it? Yes. Yes.